So as I approach the podium, let me begin by thanking Chicago Kent and Chris and Carolyn for putting together this symposium. I think you'll all agree that it's really quite a stimulating program that they put together, and certainly was kicked off in excellent fashion by Judge Posner last night. So the title of this panel is Supreme Court and Technology. And technology, the one that I want to kind of begin with is the transformation of information. In 2002, the various studies proclaimed that that was the first time when the amount of digitally recorded information matched the amount of analog recorded information on planet Earth, which is the planet I'll be addressing in my comments. And in 2007, the scales had tipped decisively in favor of digital. By that point, virtually all, 94% of recorded information was estimated to be in digital form. Lots of things that can be said about digital information. I think of greatest importance is its fluidity. It is infinitely reproducible, it's frictionlessly mobile, and it flows far more quickly and easily than its analog cousin ever did. Now, there are lots of consequences of this. Some of which I think you're going to hear more about today, even shortly after I'm done speaking. There is now much more information available about the Supreme Court than there ever was before. A SCOTUS blog, published by Tom Goldstein, and the OIE project, founded and run with a vision by Jerry Goldman, make widely available a level of information that used to be only accessible to a small group of dedicated court watchers. Talk of open access and transparency is everywhere in evidence, and it's enthusiastically supported, except on the court itself. The court is accessible in many ways, but I think it's, I think as Nancy Martyr has shown in her work, there is throughout the federal bench not a prohibition against accessibility, but I'd say a kind of passive-aggressive relationship to this digitization. And Nancy does a very good job in her work of detailing the very arguments for and against greater accessibility or transparency. I'm not going to go over them here. Instead, what I'd like to discuss in the first part of my remarks are this, what advocates of digital information think is happening, and that is a movement towards a kind of open source politics. And this ideal of open source politics, I think, is antithetical to the way in which judiciary is organized, and you can imagine understandable resistance to it. But the second component of my remarks, I want to say that I actually don't think that the Supreme Court or any courts really have anything to fear from the internet, in part because the worst criticism that can be made of the court, that it is an essentially political body, is hardly widely believed. It is certainly something that's common in elite discourse, but also in public opinion, so that the claim that the court is political, which is a delegitimizing claim, is an open secret. And it coexists with faith in the court's authority. So there's nothing to be revealed here that would lead to reform. And if I have time, I'll talk a little bit about how I think this open secret persists. So, open source politics, what is that? Liquid digital information as a political proposition is usually put forward as a mechanism for checking power. That is to say that you easily and readily place information in the hands of ordinary people, and they can use it as a way of restraining authority. And this is not just a matter of identifying a few bad apples. Julian Assange, for example, seeks to have ordinary standard operating procedures of government subjected to continuous public scrutiny. As he said, it's all the regular decision making that turns a blind eye and supports unethical practices. And this is an open source idea. In open source programming, all the information in a program is made available all the time to a community of programmers who simultaneously work on this code. You have cooperation without hierarchical coordination, and if you apply this to politics, you have a fully participatory, totally transparent, fully communicated public sphere. People themselves are actively seeking information, and subjecting authority to scrutiny. In its ideal form, the claim made by people like Clay Shirky is that policy will be given shape and direction by non-moderated, self-organizing discussion and participation. Okay, that's the ideal. This ideal, I think, I can just say, doesn't suit the court, right? I mean, the court it's a public institution, that's for sure, but many of its basic processes are held in strict confidence. It's also insulated from the public by design, and it sits atop of a judicial hierarchy. So there are reasons why you can see why a court might be resistant to this open source ideal. That doesn't mean, though, I think that the court has something really deep to fear from the revolution in digital information. And let me tell you why. I think this checking function that is anticipated to come from this new era of frictionally mobile and infinitely reproducible digital information works only if exposure produces or provokes public criticism and calls for reform. Exposure can certainly have this effect, but it doesn't always have this effect. So Yevgeny Morozov, who's a kind of critic of open source politics, has pointed out that information can embarrass, but it depends on the kind of information and the context we're talking about. Some secrets are open secrets. They're already known. And in that context, revelation does not produce crisis and form. Revelation is not a radical act. The example I use in my article or essay that connects this to the court is that the most fundamental and I think most potentially delegitimizing criticism of the court, as I mentioned at the outset, is that it is not a body of legal principle and impartial reason, but that it is instead a political body. This is a criticism that is actually older than the court itself, since the anti-federalists leveled it against the court. The notion is that the court uses its independence to advance personal political agendas rather than to engage in impartial judgment. And one might argue that the spread of digital information, the more exposure there is to the court, the more likely there is to communicate the politics of the court, or at least create images that the court is being political. This is all at the level of appearances. And that would be bad news for the court. But I don't think that's true. And in part the reason why I don't think that's true is because this political suspicion is already widely held. It is something that coexists with high trust and confidence in the court. And I think we have no reason to believe that an age of free-flowing digital information, an age that is coming ever closer thanks to the efforts of Jerry and Tom, among others, is not going to be an age of judicial crisis. I have a variety of illustrations of why I think this is the case in my essay. Let me just quickly mention one, and that's public opinion around the recent healthcare decision. Prior to that decision, both before and actually after it, trust and confidence in the Supreme Court remained higher than any other national institution. Certainly higher than Congress, higher than the president. And this is true across party affiliation. So in September, for example, Gallup showed that Democrats, Republicans, and independents all have trust and confidence in the Supreme Court in the mid to high 60%, so around 65%. And this is across different political affiliations, and it holds across all kinds of different subgroups in the population. Not only that, before and after the Supreme Court decision, the most common motivating factor named by the largest number of Americans for the decision is justices' interpretation of analysis and interpretation of the law. So even in this decision, again, very politically identified decision, healthcare reform closely identified with the president. I figured that out, see, it's called Obamacare. Put it all together, it became clear to me. Even in that context, the public sees the court as a trusted arbiter. Of course, it also thinks of the court as political. Majorities of Americans before the decision thought the decision would be motivated or be made on the basis of politics. After the decision, majority of Americans thought the same thing. After the decision, more conservatives thought it was political than liberals, to be sure. But this is a very stable finding in public opinion research that not only the Supreme Court, but all courts, state courts, courts in general, are often seen as political by the public. Yet this coexists, as I say, with this faith and trust in the court itself. So The question really, I think, as we look forward to the greater expansion of communication and digitization of information about the Supreme Court, the question is not really, will this unmask the judiciary? Will it be bad for judicial legitimacy? I think really there's a prior question, which is how has judicial legitimacy been maintained in the first place? How do we have it even now, knowing that these contradictory perceptions about the court are present? It's not something that just professors see, right? This is a very common thing that ordinary people believe. And I think we're going to hear more about it later today in some panels about what ordinary people believe about the court. I have my own views about how this seemingly contradictory situation endures and persists. And I think it's rooted in a political interest, but also in habit and in pleasure. I know that talk of the Supreme Court and pleasure, these are probably not intersecting conversations usually. But there are pleasures to be had in the law. In fact, Judge Posner has written about them before in the form of sanctuary the law creates from the brutalities of conflict. I think one way of thinking about Tom Tyler's work is that courts in their assignment and conference of status of litigants in front of them, in a sense, are giving you the pleasure of being recognized as a rights-bearing subject. Now, that may not be the most fun you've ever had, but it is a kind of a pleasure, and it is legitimizing. So that I think that the court legitimacy is not just rooted in some faith that it's an impartial arbiter, because in fact that faith does not exist in some pure sense. It's always paired with, in the public mind, a suspicion or a belief that politics are at play. The judicial process nonetheless endures, and the courts remain legitimate because there are other factors that invest us in the rule of law. And these factors aren't just faith and principle, but their interest, their habit, and their pleasure. And I think we'll be hearing more about all three of those as we go forward today. Thank you.
Thank you. We're going to hear from Tom Goldstein now. And just to let everybody know, people are going to be talking for about 12 or 14 minutes. And then at the conclusion, we'll take questions from the audience. Tom?
Tremendous. Thanks so much. And thanks to the organizers for inviting me and Amy, who will appear on Linda's panel later on, and to you all for attending. I thought that I would give you background on SCOTUS blog and what it is that we've done and some of the challenges that we faced, and that maybe I can put it a little bit in the context of the previous remarks, because I do think that some of the challenges that we have faced as an institution, as a blog, relate to the fact that the court believes its interests lie in creating the impression that it is finding the objectively accurate answer to every question, so that the only thing the public really needs to understand about the court, it would say, is its opinions, because its opinions represent the correct answer to the question. And the more you learn about the court and the more you pay attention to, hey, kind of what are the potential biases of the justices, what are their ideologies, what are the briefs that were submitted to the court, what arguments were made, who were the lawyers, what were they saying, what relationships do they have to the justices, the more that suggests that in fact the court isn't finding the objectively correct answer to the question, because there isn't an objectively correct answer, that there's a lot more play in the joints, and who the justices are and who they talk to and what they hear and when and what they're feeling actually matter. And that the court's approach to the public, which is to say, we will let you get the opinions, and that the job of the public information of the Supreme Court is, Office of the Supreme Court is otherwise to make sure the public gets no other information. What it is doing is providing you the right answer, and that to legitimize the notion that there is anything else that you need to worry about is to suggest that their own work isn't quite as legitimate. And I think that is at root kind of the reason that they aren't that psyched about putting a lot more stuff out there, about having a website, which Jerry will talk about, that actually pushes out a lot of information about what they're doing. It is in part the reason that they are not going to go out of their way to even recognize SCOTUS blog, which is one of the puzzles that we spend an awful lot of time, an awful lot of money trying to cover the Supreme Court, trying to do it objectively, trying to do it in a way that's analytically critical, but is not partisanly critical, and the court won't grant us a press pass at all. So that's kind of the context in which I'll talk about a few of the challenges that we've overcome over time, and they are challenges that have been important to the growth of the blog. The blog started 10 years ago. Amy and I, in the upstairs of a house that we were renting while our house was being renovated, and I had this idea of starting a blog because there were a couple of other people who had these things called blogs, and Amy thought it was a terrible idea, and she was right. Let's be clear. But let me do it anyway. And on the first day of the blog, we had 30 hits, and at that point, we were too embarrassed to quit. And that's why we still spend so much time today working on this thing. In October term 2012, the blog will have 30 million hits. From 7.5 million visits, and so the blog has grown a lot over time. I think there were 5 challenges that I wanted to mention that we've faced that just are reflective of the issues that that arise for us as a blog. The first is a kind of crisis of mission. What is it that we are doing? When we started the blog, our idea was this. Hey, there's this thing called the internet. And a lot of people are using it for information. Wouldn't it be neat for us to use the internet as an advertising tool for our law practice? Because we were practicing in front of the court. Wouldn't it be a great way of getting kind of the name of the firm out there? Because the idea was, if you were the general counsel of IBM, you would see something on the website and you'd be like, okay, these people must know a lot about the Supreme Court, let's hire them. Turns out that's stupid. The general counsel of IBM doesn't go, okay, I could hire Ted Olson or Carter Phillips or Maureen Mahoney or those people with the website. The people with the website, yes, let's go with them. So, you know, the idea, the foundational idea behind the blog was idiotic. And that created a crisis of mission, and that is what we were pouring a lot of time into the blog to no real effect that we cared about at the time, because while we were perfectly happy to convey information about the court and provide something of a public service, it wasn't what we were trying to do. And eventually, actually after several years, we abandoned the blog's original mission and said, you know, let's try and do some good here. Let's try and be a resource for people to learn about the Supreme Court. And that really has guided everything that we've done ever since the first few years of the blog. And it relates closely to a second sort of crisis or problem that we had, and that's one of conflict of interest. You know, if you are out there trying to advertise your law firm through a website, then what you're going to talk about most is your cases. And you're not going to do it very objectively. You're not going to be like, oh, we got crushed, or oh, this argument is stupid, or that was a terrible oral argument. You know, you're just not that inclined to write that kind of stuff about yourself. But if you were going to objectively try and be a resource about the Supreme Court, you're going to have to deal with the problem that what are you going to do with your own cases? And so ironically, what started out as an effort to kind of highlight the briefs that we were filing, highlight the cases that we were arguing, highlight, you know, people who had been law clerks for us who were clerking at the Supreme Court, we abandoned all of that. We just radically changed gears, and we said, all right, when it comes to things that did the light just come on? Thank you, that's my inspiration. That's actually not true. You know, all of the things that we were doing to advertise ourselves, we just stopped completely. And we said, we are not going to write about our own cases. We're not going to write about our own people. We are going to farm out coverage of things that we are doing to other people. And we're not going to involve ourselves editorially even in them at all. And, you know, one perfect illustration is I argued a case a couple of months ago called Moncrief, in which Lyle, who has, you know, separation from us editorially when it comes to our own work, Lyle Denniston, who's our reporter who's covered the court for 50 years, is a man not lacking in confidence about his views about the court, basically said I was terrible. And that's unfortunate, but it is what it is, and he has the complete freedom to do that without hearing a single word from me to the contrary. And there are real bright lines between the editorial function of the blog and the law practice. So the blog now does the opposite of what it was originally trying to do. There are other challenges that come with the fact that people know that the blog is not more widely read perhaps than other places, but it is widely read and widely read inside the building. We can, on any given day, get 2,000 hits from the Supreme Court itself. And we constantly are pitched to write pieces and highlight cases by people in a really transparent effort to influence the justices. So the kind of conflict of interest that we were concerned about, and that is the actual conflict and the perceived conflict. We didn't want the court to believe that we were trying to influence them on our cases. Now we face the problem of other people trying to use the blog as a platform to influence the justices, and so we have to put procedures in place that really limit the way that people can try and get at the court the wrong way. And we view it as a question of both journalistic and legal ethics, which makes it a little bit of a puzzle. So, for example, there was a case last term where one of the parties had tried to lodge a variety of documents before the Supreme Court, and that were about the case, and had done so unsuccessfully. And they really pressed us to publish the documents for them in what was really, I thought, a very clear attempt to get the documents in front of the law clerks at the court and try and influence the court and its decision making, we declined to do it. A third kind of crisis that we've dealt with, or problem that we've dealt with, is just one of quality, and that is, as our mission shifted to trying to be a public service about the Supreme Court, that meant we were going to go from covering the biggest cases, the ones that the general public was most interested in, to covering all of them. That's a very time-consuming and resource-intensive thing. And so if you're not just going to collect the briefs for those cases, but you're going to write about all those cases, who's going to write about them for you? And our first solution was our, very smart, very earnest, very hardworking law students. We teach at a couple of law schools, and so our students were taking a couple of cases every term. And the difficulty with that is, if you're not just going to regurgitate what is said in the briefs or regurgitate what's said at the oral argument, if you actually want wisdom, if you want the reader to actually learn something distinct and different, you're going to need people with actual experience, and law students just don't have it. And so what we have focused on very much in the past few years is getting experts who are writing about all of the cases rather than our students. And so we've had the great good fortune that, when you have 30 million hits during the course of the year, we actually have, we had some incredibly tiny little technical case who was written up for us last term by Richard Epstein. Where we have had the real opportunity to get a tremendous number of really high quality people writing for the blog, and that's been a great benefit to us. So our, dealing with the problem of quality has been an important transition for us, so that we can get better and better material in front of the public. Two other quick things. We've had a real issue related to our audience. Lyle, I think one of the reasons that Lyle works, 18 hours a day is that he finally has the audience that he really wants. And the audience that he really wants are really sophisticated lawyers. Lyle really enjoys the fact that he doesn't have to go, like a lot of journalists are expected by their editors to go and get a quote from someone. Lyle can tell you what he thinks about the case and write at a very high level of sophistication. Well, as the blog has become better known, including, for example, through the healthcare case, which Amy will talk about later, we have really had to deal with the fact that more and more of our readers aren't sophisticated lawyers. We have a lot of people who didn't graduate from high school, who are just trying to learn about the Supreme Court. And so Amy has been writing a feature called Plain English. Lyle has the cases made simple. And so we are trying to deal with the diversity of our audience by writing in multiple different voices. And then sort of capping all of that off is a question of resources. As the blog grew over time, it now has 3 full-time staff, 2 part-time staff, about 15 or so, and that's in addition to the students who do the roundup, or 3 part-time staff, about 15 regular contributors, about 100 people who write during the year. It got to the point where, as of 2010, it was costing us out of pocket $250,000 a year just to run the blog. And then we finally, which is a lot, it turns out, we were like, our kids can go to public school, it's not a problem. But fortunately we got a sponsor for the first time in Bloomberg Law, which has been awesome to us. And now the blog has a budget of about $500,000 a year. And it just gives us a lot of freedom. One of the things the blog we've really enjoyed is, while a lot of blogs look today, if you look at the Volokh conspiracy or How Appealing, just fantastic resources on the internet, they look today very much like what they looked like then, 10 years ago when all this started. Whereas the blog is, I think, on its 5th major rewrite of a platform. We have a technical team. We are, constantly developing new resources, trying to have fun with that sort of thing. We have people out collecting all of the briefs. We have great collaborative relationships with Oyez, for example, on getting the audio. And that is one of the really great, fortunate things, and that is that at a time where in the press, a lot of resources are being cut back with respect to coverage of the Supreme Court, ironically, because the Supreme Court's obviously not getting less important, we've been able to redouble and retriple the resources that we are able to commit to the court, and that has made all the difference for us. So I think that it's obviously an ongoing process. The blog is evolving in its mission, in what it's able to accomplish, in its readership. Amy now spends a lot of time on social media for the first time for the blog. We have 50,000 Twitter followers. I don't know what that means. We have, a Facebook page, and we'll be doing LinkedIn things. We're obviously not on the bleeding edge of anything, but trying to kind of keep up with the technology as it changes, and generationally that we can keep readers. Our hope is that as people come through law school and they come to know the blog, then they stay as readers as they are lawyers, and that other people come in. And we think that we haven't really approached the capacity of the blog and its readership. Right? It grows at about 30% a quarter, and doesn't really show any signs of stopping doing that. So we hope that it remains a public resource.
Terrific. Tom, thank you very much. Jerry Goldman.
Well, I'm in awe sitting next to Tom, and I have a chance to recognize and tell him what a great job he's doing, he and Amy, and we enjoy following the growth and the developments on SCOTUS blog, and it's just a great public resource. So I really commend you and Amy for sticking with that and making it such a great resource for all of us. My comments today are focused on criticism of the Supreme Court website, which I find not particularly useful for the vision I hold for information technology. So I entitled these remarks From Opacity to Transparency in 3 easy steps, as easy as 1, 2, 3, and I'll lay out my claim here, although the visual representation of this is much more engaging perhaps than the remarks that I'm prepared to give. The takeaway is that while I think I can make a good case for these 3 easy steps, frankly, I don't think the Supreme Court plans to move in that direction anytime soon. So the Supreme Court is an opaque institution, and its website is equally opaque. There have been some great improvements, but the improvements are molecular in nature. The original Supreme Court website was basically a group of PDF documents managed by the GPO. The Supreme Court decided to bring the website in-house and got some significant boost in resources from the Congress to do that, and that has brought the Supreme Court to where it is today. But to make it transparent really requires it to do much more than it's doing now. The 3 easy steps are basically improve accessibility, provide structure, and operate on the basis of standards. So by accessibility, I really mean getting to the information with ease. And there are 2 ways to look at this, for humans and for machines. For humans, it's still finding ways to navigate through the court's website and to click through to locate a particular piece of information that may prove valuable in your quest for knowledge. For machines, it's how can computers assist us in the work we wish to accomplish by making the content of the court's website easily understood through computation. And to me, the opportunities for the growth in big data and large data analysis requires much greater flexibility and structure and ease with which our machines can do the heavy lifting for us. One good example of accessibility concerns the court's docket sheets. Now, a docket sheet is basically a roadmap to the case, and it contains a lot of really valuable information. But what do you do with it? You ought to be able to move from the roadmap to a particular location, but the court doesn't make that possible. But SCOTUS blog does, because it's taken that docket sheet and made it an interactive document so that when you look at the docket sheet, you see, there's a brief by the respondent's been filed. I'd like to read that. Click on that link and you see and read the brief. So you've done a great job doing that and a great public service. But now the court has to step up and do more. The court, for several years now, has accepted and required electronic brief submission. And it originally said, the court said, that it was going to host its briefs on its own website, but it does not do that today. The host site for the briefs to the Supreme Court is the American Bar Association. And this website is not up to the standard we citizens should expect. While the link from the Supreme Court to the ABA's website takes you to a list of cases on the current docket, and from there to those particular briefs, try to find a brief from the 2007 term or the 2008 term. You won't get it. Those documents ought to be made available to the public and made easily accessible. The ABA is not doing that job. A good example, if I could demonstrate it to you, would be to take a look at a brief that was born at the point of submission to the Supreme Court. It's a PDF document, and it's possible to extract some information from it. But when you look at that same document provided on the ABA site, after it's been moved from the court to the ABA, it's become encrypted, locked up in a fashion, and watermarked. And for the life of me, I can't understand why the American Bar Association is putting its watermark on briefs that it didn't create. So does it claim some ownership here? Why in the world are you putting your watermark on a brief? How about putting a watermark on the Supreme Court opinion? I mean, it seems to me it's often a question from which I have not received a good answer. So the problem with the ABA is that there's no comprehensive list of cases or briefs. There's no effective search mechanism. There's no way to browse it. Basically, if I were giving it a grade, I'd give it an F. And that's definitely not worthy of the public. And ironically, the ABA website does indicate that it provides comprehensive coverage of the U.S. Supreme Court. So a little truth in advertising would be helpful. The second step that the court needs to take is to provide some structure to its documents. That means, to my way of thinking, an index of all the information for a document. So if you were to look at the Supreme Court's opinion, 150 or so page opinion in the Affordable Care Act, you'll see lots of data on that document. You know, you'll have docket numbers spread out all over the page, and you'll have the parties' names in various locations, and you'll have information about how the case arose and where it came from, and the date that it was decided, and who and the participants in that. Now, for us as humans, we can figure this all out, but for machines, it's really difficult. And we really need to figure out, the court needs to help us, the computing public, to structure its documents in a way that will be easily parsable, that we can say, I know this is a docket number. Tell me, these are the parties. This is the date that this document was born, and so forth. So providing structure is critical for us to achieve the ability of greater computational value in the documents that the court produces and the documents that the court requires of its parties. Absent that, we struggle to try to figure out how to unlock the data from the court's PDFs. So we're hoping that structure will help us. Some wonderful examples from just any batch of briefs is that there's no consistent logic or order to the way party names are displayed and where they're displayed, what kind of brief it is, which side the brief supports, who are the authors, what are their addresses, how do you contact them. I mean, it's just a nightmare to try to unlock this information from the court's electronic submissions. And it would help us enormously if the court just took a small step to instruct the brief writers to provide that information or itself provide that through the metadata that it can create to accompany these documents. So the grand plan for us, of course, is to hope that someday we will be able to obtain this information in a consistent format and in a manner that we will then be able to share along with 110 million words of transcripts identified for every speaker going back to 1955, which is a grand vision we've held for a long time for the OEA project. Moving on to my third point, after I go through all my the fun I was going to have with my slides, one more, standards. This has been a hobby horse I've been on for a long time. Standards are basically accepted benchmarks and conventions that apply to any particular medium. I'm particularly interested in audio and have been for quite a while, when I knew that I could obtain copies of the court's public sessions from the National Archives. Well, as many of you know, from 1955 to about 2003 or 4, these public sessions were recorded on reel-to-reel acetate, quarter-inch acetate tape, and stored in the National Archives. Today, the audio materials are created digitally, in part because the tape manufacturers were going out of business. But the Supreme Court has decided in its wisdom to record its public sessions to MP3. MP3 is a delivery standard that most of you are familiar with if you have an iPad or an iPhone or any other, if you listen to audio on your computer, more than likely you're listening to an MP3. Now an MP3, as I said, is a delivery standard. It's a standard in which, for acoustic reasons, the recorder or the generator throws away information that is generally beyond the capacity of humans to hear, but it's still information that captures what happens in a recording environment. It's also not an archival standard. So what the court really should be doing is making recordings in a recording format that all audio archivists support, WAVE or AIFF. These are lossless standards that capture every bit of information. The value in using a recording standard rather than a delivery standard is that at some point we may discover a new standard for delivery. It won't be MP3, maybe it'll be JG2. Whatever it is, we will abandon MP3 and move to some other acceptable and perhaps better delivery standard, but we will have lost the archival element that we would want to go back and revisit to generate to this new standard. I can't tell you how many times I have tried to get the court to recognize that it's not playing the game fairly by using these generating MP3s at the birth of the audio that it creates. But I continue to plug ahead with my pitch. So, 3 easy steps. The court needs to finally do something that all of us recognize would be really helpful: add RSS to its website. RSS is a syndication, real simple syndication or rich site syndication, which enables us as users to say, okay, now that I've subscribed to the court's website, anytime it changes anything, I'll know about it and I'll have that information. So I don't have to go back 15 times a day and say, gee, did they post that argument? Did they post this audio? I will be informed from the court to me. The court should also host all its content and link to it rather than parcel it out to organizations that don't do a credible job. Second, it should unlock all its information. There should be no encryption. The information should be machine readable, and it should be in a structured format. Finally, it should comply with accepted archival standards. And having made my pitch for those 3 points, I'm confident that the court will not follow them.
Thank you, Jerry. And our last speaker on this panel will be Nancy Martyr.
Oh, excellent. Excellent. So let's see. All right. Good morning. I'm going to be speaking about the court and the visual, images and artifacts in U.S. Supreme Court opinions. And my focus is going to be on Supreme Court use of maps, photos, and other images in their opinions. And one of the few articles on this subject suggests that the Supreme Court should not use visuals. It should just use words. I don't agree. There are times when images can be very useful. As the old adage suggests, a picture is worth 1,000 words. So in my presentation, I'd like to give you a snapshot view of how images are used with a focus on 3 paradigmatic examples, explore some of the benefits and some of the concerns I have, as well as a few recommendations for when and how they can be used most effectively. An early article by Hampton Dellinger in the Harvard Law Review found 21 cases that use images. I doubt this is complete, but the study was done in 1997, and so I decided to take up where that article left off. From 1997 to 2009, so the last 12 years for which there are US reports, there were 23 cases that used images. I know, my RA counted. And the types of images that are used, 11 maps, 5 artifacts, 3 diagrams, 3 tables, 2 photos. And the justices who used the images most, Justice Breyer, 14 times, Stevens, 5 times, Kennedy, 2 times, and then 1 each for Thomas, Ginsburg, and Rehnquist. This was a tool of the dissent. It was used by the dissent 14 times, by the majority 9 times, in a concurrence 1 time. So let me give you what I regard as 3 paradigmatic examples of images in Supreme Court opinions. The first is from a case called Karcher versus Daggett in 1983. And Justice Stevens, writing a concurrence in a reapportionment case, included a map to illustrate the shapes of the district. And you should see the map up there. And the issue is whether a reapportionment of the districts in New Jersey. Oh, that would be so good. The issue is whether the reapportionment of districts in New Jersey after New Jersey lost 1 member of the House of Representatives when it had a population decline in the 1980 census was permissible under the Equal Protection Clause. The variance in population in the new districts was less than 1%, but the court held that even a small variance fell short of absolute equality of population that the Equal Protection Clause required. And Justice Stevens suggested that the shape of the districts would be something he'd consider in addition to the numbers of the population of each district, especially in deciding whether there had been gerrymandering. And he included the map that is on the screen now, as well as some vivid descriptions in words of the shapes of the district. For example, one commentator he quoted suggested that the 7th district, and you'll see it in the center there, looks like a fishhook, and it really does. Justice Stevens discussed the shapes of the districts, and so did Justice Powell in his dissent. Both agreed that the map conveys the shapes and the lack of compactness far better than words alone, though I think it's the combination of words and map that are powerful here. In the end, both Justice Powell and Justice Stevens thought that the issue could be decided without reaching a gerrymandering question. And Justice Stevens thought the variance violated equal protection, and Justice Powell thought that it did not. Again, I found this an easy case for including the artifact in the opinion. As a practical matter, only those who read the opinion in the bound volume of the U.S. reports will see this ticket, because Lexis and Lexis Advanced did not include, whoops. I think this is an easy case, but the unfortunate part, again, in U.S. reports you can see this map, but the online version of Lexis does not have this map, nor does Lexis Advanced, Hein Online, and the case is too early to be included on the Supreme Court website. And Westlaw Next have small images if you print out the opinion. So this is a case where the map is integral to the argument, and the map and the words help each other, but you only really get the map if you look at the bound volume of U.S. reports. I think the next case is also an easy case for including the image. This is Carnival Cruise against Shute, a 1991 case. And Justice Stevens, writing a dissent joined by Justice Marshall, used a fold-out actual-size reproduction of a ticket found in the Carnival Cruise case. It's what's issued to a passenger. And the issue was whether Mrs. Shute, who was injured in a slip and fall aboard a Carnival cruise ship, whether she could sue in her home state of Washington or whether she had to sue in Florida, as the forum selection clause on the reverse side of the ticket provided. Justice Blackmun began his opinion with the relevant language, the forum selection clause, as well as the warning in caps that appeared on the front side, indicating that you had to read the reverse side. So you see at the bottom, it says, subject to conditions of contract on last page, important, please read. And then that's your next page, and it's in teeny font. And you would have to go to paragraph number 8 to figure out the forum selection. So you would need to know to look at the reverse size and to really get a sense of what the consumer sees, the small type, the legalese, the lengthy contract. You really do need to see that ticket. Plus, the consumer had to purchase the ticket first, which said you get no refund, so you have no chance to bargain for the contract terms. Again, the inclusion of the ticket strengthens the dissent and counters the point made by the majority opinion. And again, I find this a fairly easy case for including the artifact in the opinion. As a practical matter, only those who read the opinion in the U.S. reports will see the ticket. In Lexis and Lexis Advanced, no ticket, just the following phrase, see exhibit in the original. In Westlaw Next, it's unreadable. It looks like hieroglyphics. So you have to go back to the U.S. reports, bound volume, in order to see this ticket. The last example I want to give you is a more recent case, 2011, Brown against Plata. It's a prison case challenging whether a court-mandated population limit was necessary to remedy the violation of the prisoner's constitutional rights. And the court's opinion was written by Justice Kennedy, and it upheld the 3-judge district court order requiring the California prison system to reduce its prison population so that it didn't exceed 137.5% of its maximum capacity. and the extreme overcrowding of the prison. The prisons were occupied to 200% of design capacity, had led to violations of two classes of prisoners, those with medical needs and those with mental health needs. At the end of Justice Kennedy's opinion is an appendix. Appendix A contains the relevant portion of the Prison Litigation Reform Act of 1995. Appendix B shows this photo and the next photo, and Appendix C shows this photo. And I'll go back to these photos in a moment. In his opinion, Justice Kennedy cites the first two photos, but doesn't discuss them. And in his opinion, he mentions the third photo because it depicts, quote, tiny phone booth-sized cages, end quote, where prisoners in a mental health crisis can be held. I think there are problems with the first two photos, and they raise more questions than they answer. There's no description in Justice Kennedy's opinion about these two photos. And you can see there's not much description here, Mule Creek State Prison or California Institution for Men. And certainly they show people living in crowded conditions, beds and people are everywhere. But how representative are these photos? Are these people with medical or mental health needs? How big are these rooms? It would be useful to show the entire room. And there's no mention of these photos in the dissent. So Justice Kennedy doesn't describe them and the dissent doesn't critique them. The last photo, though, I think is more effective. First of all, the description is more helpful. You get dry cages holding cells for people waiting for mental health crisis bed. I also find this photo stark and chilling. It shows the inhumane conditions in which a person in the midst of a mental health crisis would be held. There's no prisoner in the cage here, so you, the viewer, can imagine what it would be like if you were in that cage. And there are only numbers. There's 102 on the room, there's number 2 on the cage, and Justice Kennedy offers a description from an expert, and he says, one prisoner was held for 24 hours, and when he was found in this cage, it was in a puddle of his own urine. He was non-responsive and just about catatonic. And it shows the importance of having the justice explain why he included the photo, and that you can't take for granted that everyone will see the same thing in a photo. And the justices need to explain in words why they've included the photo. The dissenting justices didn't refer to this photo, and they should. They should challenge the photo the way they would challenge a footnote or a precedent. And they need to have an exchange about the images if they're going to include them. They might not have that exchange because the photos could be added late in the process before they've finished exchanging drafts. On a practical level, you would see the photos in the slip opinion on the Supreme Court website. The US reports has not been published yet. Lexis and Lexis Advanced included 2 of the 3 photos, but they mismatched the photos and the captions underneath. And Westlaw and Westlaw Next have all 3 photos, but they're dark and grainy, so they're really hard to see. Once again, online readers will not get the full effect of the images. I think there are benefits to including images. It's another tool that justices can use to make their argument. I think they work best when there's discussion in the text, and the text and the image work powerfully together. They provide information that the text alone doesn't convey sufficiently: the irregular shapes of the districts, the small size print in the lengthy contract. And they may make opinions more accessible to younger law students and to younger lawyers raised on images and icons. They may even make opinions more accessible to the public, one of the themes of this conference, giving them an image with which to better understand the case. I do have some concerns, though. The justices don't challenge or critique photos as often as they do, say, footnotes or cases. And if they're part of the argument, they should be part of the debate. The justices need to explain the photos in Brown against Plata or the video in Scott against Harris. They can be interpreted in more than one way. Images, especially photos, can be very powerful. You can remember the photo long after you're going to remember the statistics or the testimony of the experts in Brown against Plata, for example. But what about the problem of powerful photos used in controversial, emotionally charged issues like abortion? There's also the practical problem of online versions of opinion that don't always include images, or if they do, the images are not clear. In my view, if they're part of the opinion, they need to be included. So a few brief recommendations. Justices who include images should think carefully about what the images add to their opinions. And if they think it strengthens their opinion, they should explain it in words why they've included the image in their text. And there's a need for explanation and for interpretation because there are multiple interpretations, especially with photos. Similarly, justices need to critique and to challenge and to show why a photo raises questions or doesn't resolve the issue. And they need to point out distortions in photos or videos. We all need to become more critical in our viewing of images in still photos or videos. And as a practical matter, if images are part of the court's opinion, they need to be included in online versions of the opinions. Technology might not have permitted images in online versions originally, but today it's no longer a bar, particularly as we all move from reading opinions in books to reading opinions online. The images need to be included. The images should be used by justices, but only when they make a point that's hard to convey with words alone. And just as justices think carefully about the language they use in an opinion and consider that their opinion, once published, is out in the public domain, they need to think carefully about the images they use in an opinion and make sure that the ones they choose are ones that will enhance rather than diminish the public debate, especially when the subject matter involves deeply held and deeply contested points of view. Thank you.
Well, thank you very much. We can entertain some questions now. All right, well, I have a question to start with. And Keith, I understood your open source politics to be tantamount to more information is always better. Tom elected not to publish on his website certain materials. I'd like to have you both discuss whether Keith is right or whether Tom's right. You know, whether, in other words, whether I take Tom's position to be that under certain circumstances to protect the institution, it's important to keep some information back. Is that something that could be generalized to the court?
I'd like to answer by saying we're both right. Okay. I didn't bring up open source politics necessarily to endorse it. I think it is an ideal that is, in fact, threatening not only to the court as an institution, but is threatening to a lot of standard journalistic practices, editorial control, for example, in journalism. The idea of open source is to take this information out of the hands of any conceivable set of filters and put it in the hands of people themselves directly. And the people themselves will consume and evaluate and then publish their own views of this. And so I think if taken to its in its ideal form, it's a radically decentering and participatory ideal of politics and society. I brought it up as something that if one sees that trajectory, and certainly someone like Julian Assange believes in this, but many other people do. He's not alone. And I think it would create real problems for the court, but also would be antithetical to the kind of choice that I think SCOTUS Blog rightly made. So I think we're actually in heated agreement.
Well, it's a real puzzle for us, and we don't have a great answer. I'll tell you. So I gave you the example of the dilemma of, hey, there are a bunch of documents relevant to a case that members of the public might be interested in, but we think that they're being pitched to us in order to, for the wrong reason, the unethical reason, legal, as lawyers, unethical reason, not journalistically unethical, of trying to influence the court. Well, here's the tougher one. There have been about 10 times that we have known something that was happening at the Supreme Court that the court didn't want the public to know. We've known about cases being granted before the court released the information. We've known about cases being decided. We've known what the decisions were. Because if we watch the court with ferocity, and if you pay attention to any institution, and these aren't leaks, right? There's only been kind of 1.5 times where some member of the court or its staff kind of let a piece of secret information out that we had. The rest of the time have been technological screw-ups. The court's phone system, when it used to have a phone system, the court's website, the court's online docket, has every once in a while, it's a bureaucracy, it's a big institution, it messes up and it releases a piece of information. And then we are really torn. Because on the one hand, you could say we have a journalistic responsibility, it's a governmental action to get that information into the hands of the public. On the other hand, we're members of the bar of the court, and we have a responsibility to the institution, we think, as lawyers, to tell the court and, in a sense, to protect the court from itself. And we have resolved that question in a kind of odd way, and that is that if I discover the information, then I deal with it as a lawyer rather than as a journalist or the publisher of the blog. And it's almost always me, because and if it were Lyle, then Lyle would have all the journalistic freedom as a reporter to do with it as he thought appropriate. But Lyle tends to work from a core set of materials that don't interact with electronic things. He does blog very actively, but he's not watching the court's website. He's he's doing classical journalistic work, going through the briefs, waiting for the decisions to be handed to him. He's not an investigative reporter. He doesn't really hold that as a high value. And the way we've always resolved it, and there have been about 10 times, we have told the court uniformly, you have accidentally just let everybody know that you're granting cert in these 4 cases 3 days early. You have just released the opinions 45 minutes early. Did you really mean to do that? And those sorts of things. And it is a real puzzle for us about what to do in that circumstance. And I don't know that we've decided the right way of doing it, but it is how we've come at it, and it is very much not open source at all. We act as a filter, and our readers may not know that we're doing that. So I'm not sure it's the right answer.
May I comment? This may explain why the court won't introduce RSS, for fear that it's posted something on its docket that would reveal in advance information it would not want the public to know. But then again, I would argue that it still ought to implement RSS, and if there are these screw-ups, then you take precautions. You have a higher level of care. It's not, I understand the dilemma that you face as a lawyer, but as a citizen educator, I think that this information ought to be shared. The court ought to be providing better services to the public. And if the price they pay is that someone screws up and loses his job, well, that's the price for a higher level of care.
So they've done I'll give you one example of that. Last term, I think it could have been the term before that, the court had developed a practice that when it released the opinions in the court, it would almost immediately, within a minute or two, publish them on the website. That was a really nice thing. It was part of the issue as it related to healthcare. It used to be when the healthcare decision came down, but nobody could get a copy if you weren't at the building. It used to be that the court would immediately email some copies out, including to the Solicitor General's office. It developed such false confidence in its own website that it stopped doing that. When the website effectively crashed in its ability to handle new opinions, nobody outside the building had a copy. But when the court last term published its opinions one day about 45 minutes early, they did put a higher level of review. And so now it takes about 6 or 7 minutes for the opinions to be published electronically by the building, because somebody has to say, yes, I've really confirmed we've released this opinion. The most infamous example of this happening, this screw-up, was one of the major things that led the court to take over control of its own website. As Jerry mentioned, originally it was run by GPO. And in Bush versus Palm Beach County Canvassing Board, the court famously heard oral argument in the case and GPO pressed the button to release the opinion while the court was on the bench. And that led to, it was a bit of a debacle. And then they repeated the debacle last year when they were running their own website and released opinions at like 9:20 in the morning one day. And now there's about a 5-minute lag on getting the opinions out.
Just one further comment. We've had our own advantage in scooping the audio because in the ACA cases, I think we released the court's audio before the court did, but because there was so much interest in what the court was doing, I don't think anybody but the three of us associated with the OYE project knew that we were pushing it out earlier to the public. But if it's there and we locate it, I think our mission is to share it with the public because they deserve it. But good that they're implementing higher standards to make sure that they protect their own institutional interests.
Chris?
Open House was really enlightening. So I was in law school not so long ago, and at that time, all of the justices on the Supreme Court, or none of the justices on the Supreme Court, checked their own email, or perhaps used email at all, despite the fact that they were repeatedly issuing opinions with respect to the internet. My sense is that at least half the court has changed over since then, and maybe they are more technologically savvy now than they were a decade ago. But is the lag between the Supreme Court and the rest of us shrinking? Will it ever shrink entirely, or at least is it shrunk enough, or can we hope that it will shrink enough in the next, say, 5 or 10 years, that there will not be meaningful differences between the technological savvy interests of the members of the court and the rest of us consumers?
Well, the court is halfway through a demographic transition between a set of justices who are in their 50s and a set of justices who are in their 70s. And the justices who are in their 50s certainly do use emails. One of them uses a BlackBerry and stays in, touch that way. The technological savvy, when you look at the top 1,000 criteria that presidents use in selecting nominees for the Supreme Court, doesn't come close to making the list. And neither, it turns out, is real-world experience of any kind. And so I do think that there'll be a significant lag for, almost indefinitely because, even if Moore's Law eventually gets caught up, just the generational transitions and savvy, take Twitter, take Facebook, take LinkedIn, take things like that. I do think that we're not long for the world where a couple of years ago you had an oral argument in which a justice of the Supreme Court asked, "What's a pager?" Right? I mean, that was like a nasty flashback. So I don't think we'll face quite that problem. But the court as an institution values inertia and slowness rather than fastness. It doesn't place any value on really grasping things that are on the cutting edge. You'll recall the kind of criticism that Justice Kennedy got for saying, "I looked up on Google something." So I do think that the judiciary as an institution is very unlikely, and the Supreme Court particularly unlikely, to be either individually with respect to the justices or institutionally with things like the website, anything other than 10 years behind. And, one thing we haven't really talked about here, and hopefully you'll get talked about today, is obviously cameras in the courtroom, where the justices are going to lag at least a quarter century behind what, any, at least a quarter century behind what a lot of people are doing.
I would just add that there is a pressure, and that is from the law clerks, so that even though there is this generational gap, the law clerks put pressure on the justices and on the court to become updated a bit. And even though I clerked there 20 years ago, during the 2 years I was there, we made the transition from, and Dan was there too, from mainframe to personal computer, and one of the law clerks was responsible for that change. It was not me.
There may be one hopeful sign. There's a new official who's listed publicly on court documents, and he's the Director of Information Technology. He falls below the librarian, the clerk, the marshal, reporter of decisions, but he's a real guy.
He has this amazing abacus. Very impressive. It's like 12 different rows on it.
Made of marble.
I've got to get one of those.
All right. Well, I think that'll be it for the panel here. So you said that use of BlackBerry was technological savvy.
Yes.
Okay, that's interesting. Thanks very much. And we come back at 10:30. Is that correct? Yes. Okay, so we have a few minutes break. Thank you.
Great.